Hello, I'm Nicola Lloyd and I head up the Cornwall Trade and Investment Project. Our mission is to support great businesses to locate and grow in Cornwall. I'm delighted to welcome you to what is set to be a highly informative session regarding the considerations you may find helpful when expanding your team. The session will be delivered by Workplace Lawyers Doyle Clayton, who have recently expanded to Cornwall themselves with existing offices in London and Reading. So it's a great pleasure to introduce you to Declan and Dominic from Doyle Clayton, who will now talk you through their 5 key legal and compliance tips to help you expand and retain your team.
Excellent, thanks very much. So I'm Declan Bradley. I'm a senior employment lawyer at Doyle Clayton. Now, as you mentioned, it is a professional services focused firm with its roots traditionally in London and Reading, but we have expanded to Cornwall very recently. I'm now permanently based here and I'll be working out of the Cornwall Innovation Centre in Penryn campus from the start of November.
And I'm Dominic Ring, a corporate and commercial solicitor with Doyle Clayton, also based here in the Southwest. I work with companies across many sectors, from startups to multinationals, to assist with a multitude of requirements from drafting shareholder agreements and articles, and commercial terms and conditions and agreements, to mergers and acquisitions and funding and investment work.
So Doyle Clayton has been expanding recently, as I mentioned, over the past few years in terms of those geographies that we cover and also in terms of the legal services that we cover. So we're well used to help clients in that same position where they're also expanding. So what we've done today is we've put together a sort of whistle-stop tour of 5 key legal issues to consider where you are growing your team, growing into a new business area, growing into a new geography. Okay, so the first consideration to think about is what kind of staffing resource do you need to succeed in that new business area or that new geography. Okay, and we'll look at some options and the pros and cons of each. All right, so the first and most obvious choice for staffing resource is direct staff. So that's either employees or workers. So everyone knows what employees are. They are the staff with all the rights. They have, for example, unfair dismissal protection after 2 years of service. Then we have workers. So they're a bit like employees, except they work a bit more flexibly and they can pick and choose when they work, and sometimes they can choose if they work a day or not. And because of that flexibility, they have less employment rights than employees, but both do have lots of employment rights. For example, they both have the right to holiday pay, national minimum wage, pension contributions, that kind of thing. And any amounts that are paid to them will have to be run through a PAYE payroll. So there are lots of compliance things to think about when hiring your direct staff. But the benefit is that you can make them part of your team and you can really control how they deliver their service. You can't, and you really shouldn't do that with self-employed consultants. So self-employed consultants, you should engage on a business to business basis. So what that means is that they should not have employment rights, except maybe for discrimination in certain circumstances. And you can also then pay them gross, so you don't have to run payroll. So that's all good stuff, but the drawbacks to using self-employed consultants is that you can't make them part of your team. You shouldn't be controlling how they deliver their service, and they might not always be available because they should have other clients. Also, with consultants, do bear in mind that sometimes they can turn around and try and claim to be employees and claim for employment rights. And you may have seen that in the news with Uber drivers and delivery people, etc. That would require a whole webinar in itself. So if that sounds relevant to you, feel free to get in touch and we can discuss. Sort of related to that is what's called the IR35 reforms, and I'll talk more about those later. So we won't dwell on them now, but just be aware that if the IR35 reforms do bite in relation to any consultants that you have, there will be extra compliance steps. Right, so another option to consider for staff are agency workers. So that's where a recruitment company actually hires or engages the agency workers themselves and then parachutes them into your business to perform service and work. So you don't have to hire them direct. So that means you have less employment obligations to agency workers than you would do with your own staff. However, you and the recruitment company will have to comply with the Agency Worker Regulations 2010. And the main obligation there being that at week 12 of the assignment, the agency worker must be paid the same as your direct comparable staff.
Another option, or hands-off option for a company, may be to outsource its requirements or obligations to another company. So a B2B, business-to-business arrangement. Any such engagement by one company for the supply of services by another will naturally be governed by an appropriately drafted services contract. Under such an arrangement, the service provider will employ its own staff to undertake its obligations. So this option will remove any potential additional employment obligations from the customer company. Such service agreements can take different forms, including a bespoke one-off agreement for services, a framework style agreement, or sometimes known as a master services agreement, where the customer can request the services via statements of work or work orders, or a bespoke set of terms and conditions specifically for use over a series of engagements. Any such agreement will be governed by specific issues relevant to the parties, such as where the parties are located in different countries. There may be jurisdictional issues. If there are regulatory requirements relevant to a particular sector, or if any such agreement is governed by public procurement rules. One major and important point to consider in the context of any such arrangement is TUPE. This stands for the Transfer of Undertakings, Protection of Employment Regulations, and this may apply to such a B2B contract for services where there is what's called a service provision change. Broadly, a service provision change is where there is a change in the entity responsible for providing the service, with the effect that employees engaged in the service up to the date of that change will automatically transfer to the new supplier on their current employment terms. Such provision changes often happen in outsourcing contracts, but they may also occur in some service arrangements as well. The effect of TUPE is that the entity inheriting these employees in a services context, that will naturally be the supplier, will be liable for certain obligations that arise as a result of the transfer. To mitigate the effects of TUPE, the supplier will often seek protection within the agreement from the customer to cover the costs of meeting these obligations, such as contractual warranties and potentially indemnities. And we'll discuss key clauses of such B2B agreements a little later.
Okay. So the next tip that we're going to discuss is whatever resource you do decide to use. Now you're going to have to make sure that you have the appropriate documentation, policies and practices, etc. in place. So for employees and workers, so since April 2020, you must have in place for both employees and workers. It used to just be employees, but now it's for both. Now you must have in place what's called a written statement of particulars of employment. So that's a list of entitlements that the individual must receive. So things like rates of pay, intervals of pay, working hours, holiday entitlement, holiday pay, all that kind of stuff should be listed out. But you'll want more than that to protect your business. Now you'll want a full employment contract in most cases with commercial protection such as relocation clauses. So if you are moving to a new geography, a new work site, and you want some current employees to go there, then having a relocation clause may help with that. They are quite tricky to draft and to enforce, so please do take advice as needed. You also want some more standard commercial protections in the contract, like confidentiality, obligations on the employees so they don't misuse your sensitive information. You want intellectual property rights so that it's confirmed in the contract that whatever the employee creates for you belongs to you. And then you also want likely post-termination restrictions with important and senior staff, such as non-competes, non-solicitation of clients. And those usually apply for, say, 6 to 12 months after termination of employment. So again, those need to be drafted very carefully to be enforceable, so do take advice. In terms of changes to employment contracts in light of COVID, just to mention this quickly, that we are seeing employers putting in clauses which allow the adoption of furlough type schemes more easily, to put employees on short time working and temporary layoff arrangements more easily as well. So aside from the employment contract, you'll also need to have certain staff data protection documents in place. So you need a staff privacy notice setting out how you process data about staff, and that's required under GDPR. As an employer, you should also have what's called an appropriate policy document for processing special categories of data like health data and criminal records data of your staff. And also, as your business grows and you might have different teams with different managers, you want a consistent HR approach, and a staff handbook with lots of policies in there will help with that. And you find that employers tend to start putting those in place when they have 5 or more employees, because at 5 employees, you must have a health and safety policy anyway. Okay, so on consultancy agreements, there's nothing mandatory which you have to put in place with a consultant, except maybe having a privacy notice to cover the individual contractor and your data processing activities in relation to them. But despite there being nothing mandatory to put in place in terms of a commercial agreement, it's still advised that you have one in place to commercially protect your business. So you want to set up very clear deliverables so that the contractor knows what it needs to do, and you can assess that they're doing what they're supposed to do. You'll also want some confidentiality obligations in there like you have with your staff. And also, very importantly, you'll want what's called an IP assignment, an intellectual property assignment. So that's a clause where the contractor legally gives you ownership of the IP and the work product that they create. If that is not in there, then the fallback position in the UK is that the consultant may own the IP. So that could be an issue if you go to sell the business and the IP is important, because a buyer may raise that as part of due diligence. You also might find a contractor a few years down the line, after you using their IP, they pop up and say, actually, I want the royalty for the use of that IP. So definitely something to bear in mind, that if you have a consultancy agreement, make sure there's an IP assignment in there. In terms of IR35, which I'll talk about a bit later in more detail, but in terms of the contract, when IR35 is in play, there is compliance obligations that you must comply with. And so the agreement should set out how the parties will cooperate to achieve compliance. And also, if you pay the contractor, then you'll probably want in the commercial agreement some kind of clause which allows you to lower the fee if you end up having to pay taxes that you didn't envisage at the start, which can be a consequence of IR35. So in terms of the contract you'd have in place with a recruitment company for agency workers, now, as I mentioned, you will have to cooperate with that recruitment company to satisfy day 1 rights of the agency worker. So that's access to facilities like a canteen, for example. And at week 12, the agency worker has to be paid the same as your direct comparable staff. So you're going to have to provide information to the recruitment company so that the recruitment company can pay the agency worker. And what you'll want is an agreement setting out that information flow, that cooperation. You'll also want in the agreement some kind of right of inspection, so you can inspect the recruitment company's records so you can ensure the agency workers are being paid appropriately. And also, if they're not, if the recruitment company doesn't pass on the monies appropriately and the agency worker bring claims against you, you'll want an indemnity in that contract so you can then claim off the recruitment company. But before you even get to putting in place a contract with the recruitment company, what you'll want to do is your due diligence on them, because unfortunately not all recruitment companies are reliable and creditworthy. And what can happen is that even if you pay all the amounts that are due to the recruitment company to pass on to the agency worker, if that recruitment company doesn't pass them on and then say goes insolvent, it's likely you that the agency worker is going to claim against. And there have been examples like with the London Underground, the hirer having to pay twice. So definitely a warning there to do your due diligence on your suppliers.
Moving on to looking at the business-to-business commercial service agreements discussed previously, there are several key clauses to be mindful of. These may include identifying the parties involved. May sound obvious, but it's not only identifying the service provider, but also the service recipients. So that should be determined at the outset. In most straightforward arrangements, that will just be one supplier and one recipient. However, if other members of the customer's corporate group will also be receiving the services, the parties will need to clarify that within the agreement and also consider whether the other group companies can procure the services direct. And if so, whether that recipient, rather than the customer itself, assumes the payment obligations. Clarity on the services themselves are, of course, of paramount importance. The customer needs to have a clear understanding of the scope of the services that it is intending to procure from the supplier. Having clarity on the services is key to ensuring that the services are procured through the most appropriate form of contract, whether that's a bespoke one-off agreement or a framework style agreement, and to ensuring that there is no subsequent or unexpected change in the scope of services during the performance of the contract. So there should be a comprehensive description of each services that the supplier will be providing. The standard of the performance of the services is also of great importance. The Supply of Goods and Services Act implies a term into such business-to-business contracts that the supplier will carry out the services with reasonable care and skill. In effect, this implied term establishes a negligent standard. That is, the supplier must carry out the services to that standard to prevent it from being negligent. Now, a supplier may attempt to negate or vary this implied term, but it's usually not a commercially sound position to take, as a customer is hardly likely to enter into a contract with a supplier which cannot commit to using reasonable care and skill. Other provisions would include time for the performance of the services. The contract should clearly set out the start and completion dates for provision of the services, so there is a clear expectation between the parties. Service levels should be clarified, as these provide a method of measuring the supplier's performance of the services. They are the primary contractual means, in fact, by which the customer obtains some measure of control over the services and are therefore of significant importance to the customer. As such, they will need to be clearly defined. The price, of course, this should be clearly set out, or at least the method for calculating it. If it is not set out, then there is also an implied term again in the Supply of Goods and Services Act that the customer will pay a reasonable sum for the services. But what constitutes a reasonable charge is a question of fact, so it will always be preferable to have the price agreed and clearly set out. There may as well be an exclusion or limiting of liability clause. Now, this is always a key issue in a services contract, as it is in many corporate and commercial agreements. So the limitation of liability, where it benefits the supplier of the services, must be carefully tailored to the particular transaction. And the supplier itself should ideally discuss with its insurers before finalising a limitation of liability clause, and we will consider the insurance position shortly. Data protection. Is there going to be processing of data? Contracts for services will frequently involve data processing. The UK and the EU versions of the GDPR define processing widely to include, among other things, the collection, recording, storage and exchange of personal data. If the parties will be processing personal data, they need to determine the nature of their relationship. So is that of controller to controller or controller to processor? Broadly, a controller determines the means and purpose of the processing of the personal data, while a processor acts on the instructions of the controller. Force majeure is a clause which can suspend performance obligations where a party is prevented from performing them by events outside of its control. As the supplier is responsible for most of the obligations under such a contract, it will want to draft the force majeure clause as widely as is reasonable, so that is something to be aware of. And then for a customer, you should check your supplier's insurance cover. So the customer will be keen to ensure that the supplier maintains adequate insurance to cover its liabilities. That said, such provision may lead to an increase in the cost, as the supplier will want to push any cost increases onto the customer. But in a contract for services, the following are the most common types of insurance. Professional indemnity insurance, which insures against liability arising from professional negligence. public liability insurance, which insures against liability arising from death or personal injury to third parties and damage to property. Employers' liability insurance insures against liability for injury or disease to its employees arising out of their employment. And product liability insurance, insurance against liability for injury to third parties or damage to property.
Okay, so as you have new staff come into a new workplace, or just existing staff coming back to their old workplace, you're going to have to take health and safety advice to put in place measures to deal with the ongoing COVID risks. You might also want to put in place hybrid work arrangements where people can work from home and the office in any given week, and document whatever that you do in a return to work policy. And touching on a hot topic about employee vaccinations, what I am seeing is employers are encouraging staff to be vaccinated. They're giving them time off to go and get vaccinated, things like that. They're not making it mandatory. They're not saying you must be vaccinated to come back to the workplace, because that is fraught with legal risk, except maybe in the care home setting where it will be mandatory. Okay. As a third tip for expanding your business, so as your headcount expands, as your revenue expands, you might be caught by new compliance requirements and regimes, and we'll run through some of those now. So on the IR35 reforms, which I have mentioned already anyway, so basically I'll try and summarize what is a very, very big topic. But from April 21, the new reforms came into place, which say that if your business is big enough and you engage a contractor who operates through what's called a personal service company, so that's usually a limited company owned by the contractor. So if you do that and you're caught, then you have to assess the individual contractor to see if they're employed or self-employed. And then you have to document your decision in what's called the status determination statement, and then pass that down the chain to the contractor and also any recruitment company that you engage with. If you pay that contractor or personal service company, so you're the fee payer, if the matter is employment, then you have to run payroll. If you say it's self-employment, then you take on the risk of HMRC coming at you later and disputing that assessment, and then you might have to pay penalties and interest on top. So to work out if you're big enough to be caught by the reforms, now if you satisfy two of these obligations or conditions, then likely you are caught. So if you have more than 10.2 million turnover in a financial year, more than 5.1 million on the balance sheet in a financial year, and more than 50 employees on average in a financial year, any two of those, then likely you're caught. It's a bit more complex than that, so do come and take advice as needed if you're anywhere near those thresholds. The test to work out if someone's employed or self-employed is also very complex, and again needs a whole webinar by itself. But in short, if you engage a contractor and they have to perform the service personally, they don't have other clients, you tell them what to do, when to do it, how to do it, you pay them an hourly rate or a daily rate, it's likely that they may be employed for IR35 purposes. And just very briefly, an IR35 employment decision is just for tax. It's not for employment rights. That's a separate thing. So if any of that seems relevant, feel free to get in touch to discuss. And very quickly on gender pay gap reporting. So at the 5th of April each year, if you have 250 or more employees, then you must publish information about how much men are paid in your organisation versus how much women are paid. The rules around that are quite technical and complex, including actually determining who is an employee for the purposes of that headcount. And we have a specialist team who can advise as needed.
So moving on, under the Modern Slavery Act 2015, this requires commercial operations operating in the UK that have a global turnover of £36 million or more to publish a slavery and human trafficking statement each financial year. This will set out the steps that they have taken to ensure that there is no slavery or human trafficking in their business or supply chains. So although the Act only applies to organisations that meet the turnover threshold, smaller organisations can choose to make a voluntary statement. Home Office guidance actually encourages all businesses, regardless of turnover, to be open and transparent about their recruitment practices, policies and procedures regarding modern slavery and human trafficking. Organisations making a voluntary statement may wish to include the following items, which are suggested in the Act. So the way the organisation is structured, its business and supply chains, its policies, if any, relating to modern slavery and human trafficking, its due diligence processes relating to slavery and human trafficking, and the part of its business and supply chains at risk of slavery and human trafficking, and the steps they have taken to manage that risk. We understand there are several companies in the Southwest with the B Corp status, which is voluntary meeting a certain standard of social and environmental accountability, may already be adopting and utilising such a statement. Another requirement for companies, naturally, is preparing and filing of accounts. So all limited and unlimited companies, whether or not they are trading, must keep adequate accounting records. These must be sufficient to show and explain the company's transactions and enable the directors to ensure that a formal set of accounts comply with the Companies Act 2006 and are filed each year. So the directors of every company, except for some limited exceptions around dormant companies, must prepare company accounts for each financial year. These are known as the company's individuals accounts, as opposed to those for group companies. Such accounts must be prepared in accordance with the UK Generally Accepted Accounting Practice and comprise the balance sheet and profit and loss accounts. Special provisions do apply to the annual accounts and reports of small and dormant companies, so that they may omit certain information from their accounts and file abridged accounts at Companies House. Such small and dormant companies may also be exempt from audit. To qualify for this audit exemption, and this is qualification criteria for financial years that begin on or after the 1st of January 2016, your company must have at least two of the following: an annual turnover of no more than £10.2 million, assets worth no more than £5.1 million, and or 50 or fewer employees on average. So for financial years before 2016, the qualification criteria is different, so that will need to be checked. There are also simpler accounts that may be adopted by companies qualifying as micro entities. So to qualify for that status, at least two of the following qualifying conditions must be met: annual turnover of no more than £632,000, balance sheet total must not be more than £316,000, and or average number of employees must not be more than 10. These parameters do change over time, so do check where you are, and you will need to work with your accountants to ensure you are filing the correct set of accounts. Another factor for growing, expanding companies to consider is how best to retain and attract staff. Share option schemes can provide an effective option for recruiting, retaining and motivating employees. They can also be used to align the interests of employees and senior executives with those of shareholders and ensure employees and senior management are motivated and engaged in the future prospects of the company. Another benefit is that such schemes can also be utilised to take advantage of various tax incentives and reliefs. Also, using option schemes exercisable on achieving certain targets or events also means that those entitled under such schemes are not shareholders from the outset. As such, they do not necessarily need to be involved in shareholder decision making at that stage. So in respect of those tax advantages, such share schemes can be broadly divided into those that are tax advantaged and those that are non-tax advantaged. Now, tax advantaged arrangements can be classified by the employees who are entitled to participate. And such schemes may include what's known as a company share option plan, or a CSOP, which is a scheme that enables larger, including public companies, to grant share options to employees, and where certain statutory conditions are met, any gain on the exercise of those options will be free from income tax and national insurance contributions. There are complex provisions governing which companies are permitted to adopt a CSOP and the shares that can be used. And if the plan does not come within these rules, then the plan will be fully taxable, so non-tax advantaged. Another common type of scheme is what's known as the Enterprise Management Incentive Scheme, or an EMI option scheme. Such a scheme also enjoys favourable tax treatment and are specifically targeted at smaller and higher risk trading companies. A number of requirements must be met in order for a company to qualify to grant EMI options. In particular, the company must be an independent trading company with gross assets of no more than £30 million and fewer than the equivalent of 250 full-time employees. Certain trading activities will not qualify under the EMI scheme, and there are detailed rules relating to the independence requirements and the shares that can be used. Where all the requirements are met, the exercise of the option benefits from favourable tax treatment. So for the company, a corporation tax deduction may be available when EMI options are exercised, and for the employee, there can be no income tax liability on the grant or exercise of the option, and capital gain tax will only apply over any gain in the value of the shares between the date of grant of the option and the sale of the shares. In addition, shares acquired on the exercise of EMI options may qualify for business asset disposal relief, which was known as entrepreneurs relief. We do have colleagues at Doyle Clayton who specialise in and can advise on all types of share option schemes, so do please get in touch if you wish to discuss that further. Another avenue for an expanding company and taking it in a new direction, as well as incentivizing employees and management, is via what's known as an employee ownership trust, or EOT. An EOT is a special form of employee benefit trust, which was introduced by the government in 2014 in an attempt to encourage more shareholders to set up a corporate structure similar to what's generally known as the John Lewis model. The aim of such a model is to facilitate wider employee ownership of companies, albeit via an indirect shareholding. The incentive for shareholders is that the government introduced very generous tax breaks to encourage shareholders to move to such a model. So, what are the advantages for shareholders? There will be no capital gains, income or inheritance tax liabilities arising on the disposal of a controlling interest in a company to an employee-owned trust. It will allow employees to indirectly buy the company for its shareholders without them having to use their own funds, thereby creating an immediate purchaser and addressing potential succession issues. Shareholders can sell their shares for full market value, so an independent valuation will be required. There'll be no major upheaval in the running of the company, as the current directors can remain in post, and the EOT is generally seen as a friendlier purchaser, meaning the sales process itself may be quicker, with the potential for lower fees for advisors. All of this means it's certainly a good option for owner-managed businesses, particularly where succession is a concern. What are the advantages for the employees? Well, all the employees will get an indirect stake in the company, and there are substantial practical benefits associated with being owned by an EOT, such as greater employee engagement and commitments, a greater drive for innovation, and improved business performance. Importantly, companies controlled by EOTs are also able to pay tax-free cash bonuses to their employees of up to £3,600 per employee per year. So what are the qualifying criteria? So to carry out a qualifying sale to an employee ownership trust, there are 5 key conditions to meet. A company whose shares are transferred must be a trading company. The trustees of the EOT itself must ensure the application of any benefits to all eligible employees must be on the same terms. The trustees must retain on an ongoing basis at least a 51% controlling interest in the company. The number of continuing shareholders who are directors or employees must not exceed 40% of the total number of employees of the company or group. Property held by the trust must generally be applied for the benefit of all eligible employees on the same terms, but the trustees may distinguish between employees on the basis of their current remuneration, length of service, and the hours they work. Doyle Clayton itself successfully operates as an EOT and has done since 2019. This has proven to be beneficial to the founders and majority shareholders, as well as to the employees of the company. We do have a dedicated department and lawyers who can assist companies in considering this as an option and who can take the company through the whole process. So do please let us know if you wish to be introduced to consider this further.
Okay. So as a fifth and final tip about your business expanding and legal considerations to think about, as you do expand into a new office or a new work site and you take on new staff, you may have less visibility over your data protection and confidentiality practices. What we would recommend is that as your business grows into that new geography, into that new work site, as you take on lots of new staff, do a data protection and confidentiality audit. Make sure that your relevant clauses, policies, documents, practices, procedures, everything is all up to date and fit for purpose for that new growing business that you have. If it's not, do update everything. You should also build in onboarding training. So when new staff come on board, there is data protection and confidentiality training put in place, and then that is refreshed for all staff at the very least every year. Okay, doing those kind of things will help your business. If there's a data breach, that may help you appease the UK data regulator, the ICO, known as the Information Commissioner's Office. It will also help you deal more effectively with staff who may have neglected in their duties, where unfortunately you may have to run a disciplinary process. It's much easier to run that process if you have given training and there is clauses in their documents, in their contract, that say that they should have not done what they've done, and so that will make things easier for the business. So doing all those steps can only protect your business.
So as a final thought, next steps for growth of companies. A growing business, you may well be considering such factors as funding and investment for the business over the short or long term, whether the current company structure is correct, or should the directors be thinking about isolating parts of the business within a group structure, or is the time right to think about partnering with another business, whether through a joint venture arrangement or otherwise. So while we will not go into further detail on such matters here, we can assist and would be delighted to discuss all such matters in further detail if that is of use. So do please get in touch and we can take it from there.
Yes, exactly. Look, we are here now permanently in Cornwall, and we're very keen to meet local businesses so we can grow with them here. So if you do feel that there's legal support that we can provide, feel free to get in touch and we'll set up a call, a Teams chat, a coffee somewhere in the county. And as I mentioned, I'm going to be based in Penryn campus from November in the Innovation Centre, and I'd love to host you there if that might work for you. And if you want to get in touch, our details are at the end of the slides. So if there are any questions from our audience, we'd be happy to take those now.
Thanks, Declan. I guess one of the sort of key considerations that many businesses, particularly in Cornwall, are faced with is getting access to staff from further afield and particularly Europe. And I just wondered whether there was any sort of initial advice around sort of issues and hurdles that might present, particularly after Brexit.
Yeah, so I think everyone is concerned because of Brexit in terms of immigration, though they've seen the issues with the HGV drivers. But I've had a recent chat with our immigration team, or one of my immigration colleagues, about this stuff. And apparently it's not as bad as it seems, because the Home Office is very conscious of these issues. So apparently the applications for visas are being run a lot quicker. I think it's a time period of 4 to 6 weeks. At the moment, as opposed to 2 to 3 months previously. Now, I think there's a lower skill threshold which is required to get visas, and apparently there should be a lot of new visa categories coming into play. So no, I think businesses will be able to get, hopefully, the talent that they need quickly, so they can hit the ground running with those. But we do have an immigration team who can delve into that stuff in a lot more deeper detail if anyone listening needs that.
I suppose your advice on retention of staff and those schemes is even more important when it comes to perhaps some issues in terms of recruitment, and then obviously wanting to retain those staff once you've managed to get them on board.
Well, yeah, exactly. No, it's the things that Dominic was discussing mainly. No, you want employees to feel part of the business, and you want them to feel that they have a stake in it. So that's really where those equity schemes, those option schemes, the employee ownership trust type arrangement, that's where all that comes into its own, because employees feel like they should stay as part of the business for the long term to hopefully participate in some kind of exit or sale down the line.
And we often see such schemes, just to add to that are run through from startups to much larger companies. So there's no reason why a smaller starting up company shouldn't consider such a scheme from the outset. They may want to build it into their model as they grow and they take on employees. And it certainly can be a useful tool for attracting the right employee if they know that 6 months, 12 months, 18 months down the line, they'll be offered the opportunity to participate in such a scheme.
Thank you. And I suppose one other question that I have is, again, it's quite topical, and you did touch on it just around obviously COVID restrictions and, you know, office versus home-based working. And I just wondered whether you had any sort of professional views as to where you see things going in the future from that point of view. I think, you know, we're sort of meeting a new normal, aren't we, in respect of COVID, but likewise, I think staff expectations, business, you know, sort of considerations in terms of their office requirements has totally been shaken up in the last year or two. And I just wondered whether you see any sort of legal implications from that point of view over and above what you've already discussed.
So really, unless the contract's been changed, employers can require their employees to come back to the office now. There is no rule saying that no home working is a must. So legally, employers can make employees come back. And I am seeing that in some circumstances. Some employers saying, no, we need people to come back to the office now, given the type of work that we do, given the clients that we have. We need everybody together to be in a team so we can facilitate our clients and the services in the way that we need to. I'm seeing other clients, usually with more professional services or IT-based roles where the remote working was already happening anyway, so it's just going to keep continuing for the interim anyway. I know, for example, myself, I'm still sort of managed as such by London, but now I've very much moved to Cornwall myself, and I'm providing a lot of my services remotely, and I'm sure lots and lots of other people out there will be doing the same on a permanent basis as well. So I really think it's a whole smorgasbord of stuff out there, but the legal stuff underpinning it will be to do with the employment contract. What does it say in there? Does it say the person can work remotely, or does it say that they work from the office? If they work from the office, then the employer can require them to come back. Obviously, take things on a case-by-case basis. There may be disability reasons why someone can't come back to the office at this particular time, etc. As an employment lawyer, I would always say it does depend. So do take advice on a case-by-case basis.
Great. Well, unless anybody else has any questions, then all there is to say a huge thank you to both Declan and Dominic for a great, very informative discussion on some key points that I think a lot of employers find quite a daunting topic, and so it's great to see that kind of simple overview and to understand perhaps where additional support may be beneficial. And for everybody who's watching this, obviously, if you need any of our support here at Cornwall Trade Investment, then please do find us at cornwallti.com. We'd be very happy to help you. Thank you very much.
Thank you.
Thank you.